SJC-12179, Commonwealth versus Almeida.
Amy Belger for Mr. Almeida. Good morning, Your Honors. I'd like to start by talking about issue 1 in my brief that involves Mr. Almeida's statements to Trooper Robert Lima at the hospital and the Commonwealth's use of impeachment by prior omission, what he didn't say to Trooper Almeida under those circumstances. Very briefly, I know you're familiar with the facts. What happened was Mr. Almeida was in a hospital bed in South Shore Hospital. He doesn't speak English. He was dealing with Trooper Brian Galvin, who doesn't speak Portuguese. So Trooper Lima, who speaks both English and Portuguese, comes to interpret. Brian Galvin had spoken to trial counsel and counsel for the defendant, even at that time, Jack Atwood, who asked Trooper Galvin to communicate to Mr. Almeida that he was not to make any statements to law enforcement. That was communicated in Portuguese by Trooper Lima to Mr. Almeida, said your attorney doesn't want you to say anything, gave him his Miranda rights. He got Mr. Almeida's assurances that Mr. Almeida understood the Portuguese Miranda warnings. Thereafter, Mr. Almeida began to speak to the troopers as he was in the hospital, conversationally. He began in English. He told them about his life in Brazil, that he came to the United States, that he loved this country. He worked at a pizza parlor and so forth. He then became emotionally distraught.
His family member was a police officer.
And a family member of his, that's right, was a police officer. He became emotionally distraught. As he was talking, he switched from English to Portuguese and talked to Trooper Lima in Portuguese about how he had 3 children, one of whom he did not know. And then as he was emotionally upset, said, what have I done? I've killed my woman. And Trooper Lima very appropriately immediately says to him, stop talking. Don't say anything else. You've been Mirandized. I'm a police officer. And so he stops talking. And so my issue with what happens at trial is the trial judge allows the trial prosecutor to impeach Mr. Almeida for what he then didn't say after Trooper Lima told him to stop talking. And the fundamental unfairness and violation of that, to me, is breathtaking in context, because when you look at the prejudice from that, the defense in this case, is reasonable provocation, such as it is his defense is, and it's a tragic case. You're not gonna see a case that is heart-wrenching as this in terms of what happened. It's absolutely awful. He can't wrap his head around the fact that this woman doesn't want to be with him anymore, and he can't accept the fact she doesn't want to be his woman. And we have extensive testimonies, and it's horrible the way he couldn't accept this and what he did because of his inability to accept this. But his defense at trial is, I didn't mean to kill her. I didn't set out to kill her.
Oh, his defense at trial is that she's said to him at the last second that I slept with someone else, and that's the provocation. But tell us why the prosecutor's use of the statement was volunteered, right? We don't have any issue with the statement itself, right?
I killed my woman.
Right.
What have I gone and done?
Right.
I've killed
We
my
don't
woman.
have- right,
That
this
is absolutely, that is voluntary.
Right, and
That
so they're
comes in.
allowed to use those type of statements, right? And the issue is whether they can bring up stuff that he didn't say, right?
Right, and that, after Lima tells him to stop talking,
But
they
he's been
take the
talking
position.
He's been talking for a while here about his family, the
That's
police
before.
officer, right? No, I understand that, but I guess, why is it not fair for the prosecutor to point out that he never brought up this issue about provocation? And I guess, why is that a violation? I understand it's a little different maybe than some of these other cases, but he's talking, and he never says this.
He's talking, and then he's told to stop talking. Or maybe a better way to say that is, he's reminded by the trooper, okay, I Mirandized you, stop talking, I'm a police officer. And if you're Robert Lima, you were just there when Galvin said, his attorney called and said, he doesn't want him talking. And, that's communicated to Almeida, and Almeida, initially decides, okay, he's going to listen to his attorney. Because, just backing up a little bit, before he gets the news from Galvin that his attorney called and said, don't talk to them, he was willing to talk, right? So then, Galvin, who does absolutely the right thing, so, knows he's willing to talk, says, no, guy, your attorney called. Right? He doesn't want you to talk to us. And Almeida decides he's not going to talk. Right? So Robert Lima, when he, when he all of a sudden, bursts out with, what have I gone and done? I killed my woman. It's right after that. Lima says, stop talking. Stop. Okay. So the Commonwealth then takes the position, well, he didn't say that, this was why, and this was, he just said that he killed her. He didn't get to, if he was going to, why he killed her. That certainly would be the next topic, and I would think, if you're having this conversation, that you'd take up, right? Except that he was told to stop talking. So anybody naturally would...
You might start with that, too. I killed my woman because she was sleeping with someone else, right? He didn't do that. Right?
He didn't do that, but it's I would say... either way it could play out. You could say, my woman slept with another man, so I killed her. Or you can say, I killed my woman because she slept with another man.
Right,
but I don't think it comes down to that.
He didn't say either of those two.
Huh?
He didn't say either of those two.
He said, I killed my woman, and then he was told to stop talking. We don't know what he might have said next. For the Commonwealth to then say... Okay, it's an omission because it naturally would have been said, not the way that conversation was unfolding. No, it wasn't. He was expressing remorse for what he did. That was what he was expressing. He wasn't expressing the reasons why he did it, if he was going to get to that at all. We don't know that. But in terms of, when do we allow the government to impeach a criminal defendant in this situation by prior omission? It has to be when it naturally would have been said in the situation. It is a compelling fact pattern that it would not naturally have been said when a police officer tells you to stop talking. It would not naturally have been said. And, from there, you look at, is anything he testified to at trial incompatible with what he said at the time? And it's also not incompatible in the sense that he never got to the topic.
Was it raised on cross or anything like that? Was it raised on cross of the trooper that he didn't get a chance to go on? Because
yes, okay. That was the trooper. That's in the record. It's volume 7, pages. It's 137 to 39, and page 141. When Lima that the testimony is there. The order of events of what he said, both attorneys, both the trial prosecutor, I thought, and the defense attorney were, that this is a very well-tried case. And that was covered and fleshed out very well in the record, and it is right there. So from there, when he testifies at trial, he's talking, of course, he talks about how he killed her, and then he gives this reason, what she had said to him about how she had been with another man. That comes out of trial, and then the trial prosecutor is permitted to impeach him and suggest to the jury, and very, very centrally to her whole argument, in this case was, that was a fabrication that he came up with after he got the rape kit results. And in a case like this, the issue is whether it's first-degree murder. That's the only issue in this trial. Did he commit a first-degree murder? And this is his only defense. This is his main defense to the charges. Yes, he killed her. He's certainly guilty
What do
of
we
killing
make of
her.
the fact that he says he's going to kill her multiple times before? I take it the argument it's made is that he just got this information at the last second about her sleeping with someone else, but he said he's going to kill her multiple times earlier, right, to a whole bundle of people.
He did. He did. Yes. And if you look at, the days leading up into this are just, heartbreaking when you look at what had gone on. And what people may have been in a position, right, to, but
I guess
but
I'm confused by what's heartbreaking. It's tragic, the murder is tragic, but he seems to keeps saying he's obsessing about killing her. So how do we find provocation at the last second, or at least prejudice arising out of the fact that it's a short conversation with the police officer? There's no evidence that he's told anyone else that she's sleeping with someone else, right? This all arises out of the semen that's found in the victim.
Yeah, there's no evidence that he had said that prior to anybody.
Right?
The prejudice,
Even though he's saying he's going to kill her,
he
to
is
a
saying
bundle
he's
of
going to
other
kill her.
people. Yeah.
So I think, though, that in terms of the defense, right, and the evidence, there are no witnesses to those crucial moments between when she leaves the apartment of Martin's, her friend, and when she's screaming out in the hallway. There's no witnesses to that, and he testifies as to what happened and what his state of mind was.
It doesn't happen. It's incredibly sudden, isn't it? She walks out. We hear her screaming, right?
Well, we hear from Martin's that it's 5 or 10 minutes.
That they're in the hallway together for 5 or 10 minutes, or he's going to take a shower, and then she's going to take a shower, and then she hears this.
From when she leaves, according to Martin's testimony, from when the victim leaves the apartment to when Martin's hears the victim scream, 5 or 10 minutes.
Is this the set time where the defendant goes back to the apartment to get the knife?
So according to Martin's, the victim leaves. 5 or 10 minutes later, Martin's hears her screaming and then comes out. The defendant's testimony at trial is she comes up to my apartment, she knocks on my apartment door, we walk down the stairs together. I say to her as she's leaving the building, can you not go to work today? Can you not go to work today so that you and I can talk? And she refuses that. She says, no, she's going to work. He says to the victim, I need to go back upstairs and close my apartment door because the apartment door is open. He says he goes to get a knife when he goes to close the apartment door, and his intent is going to slash her tires so that she can't go to work, so that they can talk. That's what he testifies to. So he comes back downstairs with the knife. He says, then she says to him, I slept with somebody else. And when she says that, the knife that he says he went to get to slash her tires then becomes the knife that he begins stabbing her with. That's his defense. So it is absolutely true that he had said on prior occasions he was going to kill her. In terms of first-degree murder, deliberate premeditation, extreme atrocity, and cruelty, to mitigate those charges, this is his defense, that at the time, in the moment when she says those words to him, the knife he says he went to get to slash her tires then becomes the murder weapon. Okay? So that's why it matters in terms of, what he knew when and what was in his head and what motivated him to do what he did.
But what do we do? I mean, let's assume for the sake of argument that you persuade us that there's a Doyle violation, and then we have to determine whether or not it's harmless beyond a reasonable doubt, correct?
You do. That's correct.
And what do we do with the fact that he repeatedly told people he was going to kill her before he even allegedly learned that she had slept with somebody else?
That is a difficult part of this case, but what I can say about that is he had said it many times on many occasions, over a period of time, and didn't do it.
Until he did.
Until he did, but at the moment that he did, in terms of deliberate premeditation and what a jury would consider to be satisfactory beyond a reasonable doubt of evidence of that, the defense being reasonable provocation, could jurors have looked at this and said, without that evidence that came in on the impeachment by prior omission, could jurors have looked at this and said, I don't know if, deliberate premeditation and extreme atrocity and cruelty are proven beyond a reasonable doubt, given in that moment what she said to him, if they credit that, and then he stabbed her.
How much time elapsed between him stabbing her and his statements to the state troopers?
Oh, that was it was about 24 hours. So,
4 hours?
okay, so this is the morning of the 26th that this happens, when, they're leaving for work. It's like, 7:30, 8 o'clock in the morning. The morning of the 27th, when he's in the hospital bed at South Shore Hospital. So, he's at this point, in the hospital bed, it's over, he's there, and, this conversation takes place. If there's no further questions on this.
Let me ask one more question. Would it make a difference if during his cross, was there any reference to what he said to Lima?
He said he didn't remember. His memory on cross was a lot, I don't remember. There was, did you tell Lima that you killed your woman? I don't remember. Did you say to Lima that it was because, I don't remember. So there really wasn't anything when he was testifying that shed much light on that.
And if the closing argument had been, when he did blurt something out to Lima, he did not blurt out that she was sleeping with somebody else. He blurted out, what did I go do? I killed my woman. Would that have been inappropriate?
Would that have made
Would that have been a Doyle violation?
No.
So it's really a matter of how the matter was phrased by the prosecutor.
Well, I think that, no, because he did say that, and that was admissible evidence. The prosecutor faulting him for what he didn't say to Lima after Lima told him to stop talking.
Right, I understand
was the
that, but
problem.
it would not, but if he had faulted him for not being the first thing he said before Lima told him to shut up, That would not have been a Doyle violation.
That would not have been a Doyle violation, no.
All right, thank you.
Okay.
Unless you want to use the last 40 seconds for anything.
I'll use the 40 seconds. I'd like to, I'll stay on this theme, with what I have left, that the jury should have been instructed, if you're going to let evidence like this in, that really all they're deciding is whether it's a first or not. That's all the jury's deciding in the case. They didn't know what to do with that evidence. Right, they weren't given any instruction, and I know it's not a mandatory instruction and the judge didn't have to give it, but there's plenty of case law there that talks about why it should be given in certain cases, that it's advisable, Creighton, to give an instruction when you have a situation like this. And, this is a perfect example of why you should, because the jury had no idea what to do with that evidence and how to consider it. And if they had, that very well could have made a difference on whether he was convicted of a first
So
as
you're
well.
referring to the bathroom incident?
Bathroom?
When you said the instruction that was not given, which instruction was not given?
An instruction on how a jury should consider evidence of impeachment by prior omission, that they have to
sorry.
believe.
Okay, the
So the
Doyle.
jury, if the jury was instructed on the law as to impeachment by prior omission, because again, they're not going back there trying to figure out whether he killed her. All they're doing is deliberating over whether it's a first. And I believe that really was
So what should the
instruction they should have had.
So what would the instruction have been?
You have to believe that the defendant in this situation would naturally have said what the prosecutor faults him for not saying, and just to get them to look at that and focus on that, right? And then, you also have to find that it was incompatible with what he testified to at trial, which it was not. So if the jury had, an understanding of the law on this issue.
Any case in which that instruction that you're talking about was given?
I don't have a case where it was given. I do have a case that says, that it should be given, or it would be advisable to give it if
Is that?
there's Petro. That is Clayton, 52, Mass, the Appeals Court, 2001, and Bruce, the Appeals Court, 2004. So it's not this court.
What are the
but-
sites? Sorry.
Yeah, sure. Clayton is 52, Mass Appeals Court 198. It's at page 207, and it's 2001. And Commonwealth versus Bruce is 61, Mass Appeals Court 474 at page 485, and it's from 2004.
Okay, thank you. Ms. Anderson, good morning.
Good morning, Your Honors. Audrey Anderson for the Commonwealth. If it pleases the court. The trial judge did not err in allowing evidence of the defendant's prior behavior. Excuse me, I'm going to start with the first one. The prosecutor's comments and closing arguments on the defendant's post-Miranda statements and trial testimony were proper, and not a comment on the defendant's right to remain silent, because the defendant did not remain silent. The defendant couldn't stop talking. The defendant spoke to everyone that he met, that I'm going to hurt her, she's my woman, she can't do this to me, I'm going to kill her, I'm going to do something that my mother will never talk to me again, my family won't talk to me again. The night before he killed her, he said this to people. He said this to several people. They were very worried. They called her, they spoke to her. The night before he killed her, he says he called her 392 times.
But the reference here was to what supposedly was said on the staircase moments before he killed her. All of what you described was said before that statement allegedly was said.
Yes. Then the day of the killing, he said to Miss Martin, look what she made me do. I did it for love. He pointed to her body with the knife. Miss Martin saw him stabbing her, and saw her trying to defend herself. Mr. Ferrara saw the defendant coming upstairs, bloody, and said, "What did you do?" He said, "I killed her."
Did the prosecutor, I should get the precise language, did he say he didn't tell Lima this, or did he say he didn't tell this to anybody?
He didn't tell this to anyone. He didn't tell it to.
Is that what the prosecutor said, or is that, I mean, I understand.
It's in my brief where the prosecutor is saying this wasn't told to any of the people that he told that he was going to kill her. This wasn't told to Officer Lima. This wasn't told to anyone.
This is at volume 11, 40 to 41, I think.
Oh, I have,
That's the closing argument. Or are we talking about the testimony?
it was closing arguments.
Yeah,
But in my brief, I have it,
okay.
something else. But it's definitely in my brief, the portion that they're concerned about, what the prosecutor said. But the prosecutor was perfectly able to comment on what the defendant said and what the defendant didn't say. The defendant, when he testifies, is like any other witness. His statements get to be called into question. The jury needs to hear everything that's happening.
I think that the tricky issue is, yes, he's clearly speaking voluntarily, and that's fair game. But when Lima shuts him down, as he should, can you then fault him for not giving a more complete statement? Particularly if, I haven't read the 40 to 41, maybe Justice Cipher has it right in front of her, but does he say, and he told Justice Lima this, and he didn't say to Justice Lima that? I guess, do we have that? Does he go is he that specific about what he should have said to Justice Lima, to Officer Lima?
It is the prosecutor, you say?
Is the prosecutor's closing, does the prosecutor in closing say, he didn't say to Officer Lima anything about this provocation? Because that's a little unfair because Lima shuts him down.
She didn't say that.
Okay.
She
Yes,
said,
she
you don't
did.
hear anything about this.
Wait, that's just not true.
Oh, okay,
Page
Your Honor.
40. This is the prosecutor's closing. And what does he say? I suggest to you he has some connection to the trooper because he speaks Portuguese. So he starts talking to him about his life. And he tells him how many brothers he has, and he tells him he's got children, and he tells him about his sister, and he tells him about how much he loves being here in the United States, and he tells him that he works in Famous Pizza, and he tells him that he's been here for 5 years. And then he tells him, what did I do? I killed my woman. Don't hear anything at that time about because she cheated on me. Don't hear anything about because she told me she had sex with another man or that she'd been with another man. Don't hear any of that in that moment. So the reference is specifically to what was said with Lima. Correct?
There was a reference to that, yes. I was taking literally what Justice Caffrey.
I take a liberty with what's the key part of the defense argument, but, okay, so we're dealing with what he said to Lima, so now we get back to Justice Caffrey's questions.
Okay. And your question, sorry, Your Honor?
So Justice Lima shuts him down before he elaborates. Is that a problem? In our cases, you rely on something I'm familiar with, Donovan, but it's a little different in Donovan, right? I'm just trying, are there cases like this where we've closed down the conversation?
Not that I am aware of. But I just wanted to say that after Lima told him that I'm a police officer, stop. He didn't really stop. He didn't go into detail. But he says, I know I've been Mirandized. I know you're a police officer. I just want to talk to you.
So he keeps talking after that?
He keeps talking after that.
And what does he say after that?
That's basically just what he says. He says, I know I've been Mirandized. I know you're a police officer. I just want to talk to you. And that's basically all he says.
And what does Lima say at that point? You shouldn't, right?
I don't think he really said anything.
Okay.
I think everything was over then. But the prosecutor has a right to, she's not commenting on his silence. I mean, she has a right to bring to the jury's attention everything that's involved. It was basically a new story. It can be looked at that way. You could say it was a mission, but it was basically a new story. The evidence is not guilt, not of his pretrial silence, but his pretrial statement, post-trial statement, contradicting with his trial testimony. She's not commenting on that he remained silent after he told Detective Lima that he had killed his woman. But she's just giving the jury the possible flaws in the defendant's testimony. I mean, she's just making them aware of this. And I believe that the Commonwealth has a right to do that. Are there any other questions, Your Honors, on any other issues? I just want to say, as far as 33E, that this was a crime where the defendant planned this crime. He killed the young mother of his child in a vicious, vicious manner. He told other people that he was going to do it. He told her mother, he told her aunt that he was going to do it. And we see no reason that the court should use its extraordinary powers. Thank you, Your Honors.
Thank you. We'll take our morning break.